Well, good afternoon. We are so happy to have you with us today for today's presentation. We're going to give folks a couple more minutes to join, less than 2 minutes to join. We'll give people another minute or so. We do have people joining as I speak. By the way, my name is David Hall. I'm the firm manager here at Hall Benefits Law. And again, we're so excited you could join us. Thank you for your patience. Okay, without further ado, welcome to the latest in our series of Going Viral webinars devoted to the impacts of COVID-19 on employee benefit plans. My name is David Hall. I'm the firm manager here at Hall Benefits Law, and we are excited that you've joined us today. We hope that the information and the content that you see today will be of help to you. And in that vein, we have attached as handouts in your webinar portal, as you look at your control panel, there is a pull-down menu called Handouts. And there are a number of articles there that have been written by our team, specifically relating to COVID-19 and its impact on employee benefits plans. And so we would like for you to have those. That is our gift to you. You'll also receive a copy of today's slides, and we will have the full recording, including the slides and audio, synced up on the website as soon as that becomes available through GoToWebinar. So it just takes them a little while to prep that and then for us to get it onto our website. But you will receive tomorrow a copy of these slides. I did want to mention, because of the nature of today's subject matter, that there are a couple of items that we have been answering questions about recently that we can offer help with. One of those is online HIPAA training. In the past, we've also done on-site HIPAA training. Obviously, that is not as easily done. And so if your organization or one of your clients has a need for online HIPAA training, our attorneys are available to do that for you, and you can reach out to me or submit a question to admin@hallbenefitslaw.com about how you would do that to get set up for that service. We are also offering preparation, support, and filing of Form 5500s. So if you have Forms 5500, so if you have a Form 5500 preparation, support, or filing need, please reach out to Hall Benefits Law about that need, and we'd be happy to help you. So today's webinar, Vaccinate Your Employee Benefits Plans Against the Impacts of COVID-19. I'm very happy to present to you Scott Santerre, Senior Compliance Counsel, Eric Schillinger, Senior Compliance Counsel, and Ann Tyler Hall, our founding attorney and principal. These three accomplished, experienced, and responsive attorneys are going to be covering a myriad of topics today. So if you have questions, if we skim over something and you don't hear it or you miss it, remember you will receive these slides. You can submit questions through the GoToWebinar portal, or you can submit questions to admin@hallbenefitslaw.com. Ann Tyler Hall is going to go through our agenda, and then we'll be off to the races.
Talk about. Thank you, David. There has been and continues to be a lot to talk about. So we're going to dive into, firstly, Scott's going to talk about COVID-19 and retirement plans. Specifically, we got guidance just a couple of days ago from the agencies with extensions for certain group health plan and retirement deadlines. So Scott's going to talk about that. He's also going to talk about another notice that came out earlier in April related to Form 5500 filings for those plans with an April 1 to July, on or before July 15th deadline. Scott will also be talking about plan terminations and considerations. If you're an employer or you represent employers, work with employers that are considering a retirement plan termination, a lot of litany of considerations related to that plan sponsors should be aware of. And then Scott's going to talk about retirement benefits in the Paycheck protection program and the accommodation for retirement benefits and employer contributions as part of payroll costs in the Paycheck protection program. He's also going to discuss the CARES Act distribution provisions and the loan expansion and the coronavirus-related distribution allowance under the CARES Act, and then specifically crediting service in the context of layoffs, furloughs, and leaves of absence. Next, we're going to talk about health and welfare benefits in COVID-19, and Eric will talk about plan amendments and disclosures in the context of COVID-19 testing and optional high-deductible health plan changes under CARES Act. We'll also be discussing some HIPAA considerations in the context of remote workers. Special enrollment rights, are those available explicitly related to coronavirus? Fringe benefits, whether employers can pay, for instance, tax-free for household expenses of those who work from home. And then similar to Scott, he's going to discuss the recent notice from the agencies that provided for deadline extensions for various group health plan matters. And then finally, we'll talk about executive compensation in COVID-19, and I'll talk about Code Section 409A considerations, the CARES Act and executive compensation limits that apply for employers that avail themselves of certain loans and loan guarantees under the CARES Act, and then also talk about, finally, ESOP considerations in the context of COVID-19. So with that, I'll turn it over to Scott Santerre.
Thank you, Ann Tyler and David, and jump right into, there we go, the retirement plan considerations. And as Ann Tyler already kind of gave you an overview, we're going to go over what notices 2020-01 and 2020-23 provide and how they impact retirement plans, how laying off employees can impact retirement plans for terminations, retirement benefits that can qualify under the loan forgiveness program, the Paycheck protection program. We'll very briefly discuss the CARE Act distribution and loan provisions, and then crediting service. Notice 2023. This was enacted on April 9th, and when President Trump declared a national emergency back on March 13th, some general relief was provided to individuals and corporations relating to individual tax and corporate tax filing deadlines. This Notice 2023 gives some additional relief to the individual and corporate tax filing deadlines, as well as providing some pretty substantial relief to everyone who's performing a time-sensitive action specified in the regulation or Revenue Procedure 2018-58. And that relief is basically any time-sensitive action that is required to be done between April 1st and July 15th has been extended to July. And as how this relates to retirement plans, there's quite a few provisions that are required or could be required to be done between April 1st and July 15th. And we've listed a couple of the major ones here, and we'll go over a few of them now. The first is loan and RMD deadlines. Now, both of those have already been touched on a little bit with the CARES Act that has come out recently. However, they've only touched partially on loans and partially on RMDs. For loans specifically in this notice, the loans provisions related to the 5-year repayment terms of a loan, as well as the deemed distribution for loans, those were not addressed under the CARES Act, but are addressed here. So basically, if your loan, the 5-year expiration of your loan period due between April 1st and July 15th, then automatically extends to July 15th. The same for any deemed distribution as a result of your failure to pay on your loan. If that deemed distribution is required to be paid on or after April 1st, that deadline has been extended to July 15th. The RMD deadline, again, has been addressed under the CARES Act, but it's only been addressed regarding the suspension of RMDs for defined contribution plans. It didn't address any defined benefit deadline. This notice 2020-23 now extends the defined benefit plan deadline from April 1st to July 15th. Both the deadline to distribute excess deferrals and the deadline for the ADP, ACP corrections have been extended. Those are now July 15th, and as well as the 60-day rollover deadline. 60-day rollover deadline is when an individual takes a distribution from their retirement account and they wish to continue to defer taxation on that. They need to roll over the funds into another qualified plan or IRA within 60 days of the distribution. Under this new guidance and relief, if that 60-day deadline falls on or after April 1st, they have a new deadline of July 15th, regardless of how many days have therefore elapsed. They also extend the remedial amendment period, plan contribution deadline, and then two other ones that I want to talk a little bit more about are the permissible withdrawals from an EACA plan and the Form 5500 filing. Under an EACA plan or an eligible automatic contribution arrangement, individuals who have been automatically enrolled have a certain period of time in which they can request their automatic deferrals back and they can withdraw them penalty-free. If the deadline for that request falls between April 1st and July 15th, that new deadline is July 15th. And then the Form 5500 filing, again, any Form 5500 that is required to be filed between April 1st and July 15th has been extended to July 15th. And the key thing to keep in mind here is that this is currently does not apply to calendar year plans. Calendar year plans filing deadlines already occur after July 15th, so there's currently no relief provided for them. Now, that may change depending on how long the COVID-19 pandemic continues. But as of right now, there's no relief for calendar year plans. This relief would only be for non-calendar year plans with a filing deadline between April 1st and July 15th. There was also a disaster relief notice 2020-01, and this basically extends time for plan officials to furnish benefit statements, funding notices, and other notices and disclosures as required by ERISA, as long as they make a good faith effort to furnish those documents as soon as administratively practical. The notice also gives some guidance on what constitutes a good faith effort, and that includes an electronic alternative means of communication, which has been stated to be email, text message, or a continuous access to website. As long as the plan sponsor reasonably believes that the participants or beneficiaries can access these means, then those are acceptable good faith efforts to communicate with their participants. Additionally, the notice provided some guidance on plan loans, blackout notices, late remittance of deferral and loan repayment, and then general ERISA fiduciary compliance, and how the DOL is going to kind of address any sort of failure. Basically, what the notice said was, for any failure that occurs between March 1st, 2020, which is the day that President Trump declared a national emergency related to COVID-19, and 60 days following the end of the emergency disaster, any failure with regards to these with regards to these, failure to not timely remit your deferral or loan repayment, failure to not timely provide a blackout notice, or failure to not follow procedure or requirements for plan loans or distributions, the DOL is not going to enforce. Now, in order for them not to enforce that, the plan sponsor needed to make reasonable, good faith effort to try and comply with the terms of the plan, try to remit the deferral and loan repayments timely, and try to provide the blackout notice timely. Additionally, if any sort of correction is required, specifically with failure to follow requirements for plan loans or distributions, the sponsor needs to, as soon as administratively feasible, implement those corrections. And then finally, and most importantly, the failure to meet any of those timeliness requirements had to specifically be related to COVID-19 issues. So if your failure to remit deferrals and loan repayments had nothing to do with COVID-19 related issues, then this relief will not apply to you. Finally, the general ERISA fiduciary compliance part, fiduciary has the responsibility to act reasonably, prudently, and in the interest of the participants and beneficiaries of the plan. And that includes trying to prevent losses of benefit or undue delay in benefit payment. And so the fiduciary is still responsible to try to minimize those and avoid those. But the DOL has basically said that in terms of enforcement of those, they're going to emphasize compliance assistance, which would include grace periods, other relief where appropriate. And so basically they're going to be a little bit more lax in kind of enforcing any sort of fiduciary duties in general. And again, that is specifically as it relates to COVID-19 encountered problems. There's not a general lack of enforcement. It's those issues that arise due to COVID-19. The next area that we're going to talk about are plan termination. Most of you are probably familiar with what is called a full plan termination. And that this is where a sponsor wants to terminate a plan for whatever reason and get rid of it. You typically have to 100% vest all employees, update the plan for required law changes, file a Form 5500, including a final 5500, notify your participants, distribute your assets within 12 months, and if you elect, file a Form 5310. There's some pretty significant steps in a full plan termination. However, what some of you may not be familiar with is what's called a partial plan termination. Now, with a partial plan termination, any significant reduction in workforce will trigger the partial plan termination rules. And really, they're not the only real detriment in a partial plan termination is 100% vesting of all employees who have terminated during the year of partial termination. The other things in terms of updating, filing a final 5500, notifying participants, distributing assets, filing a Form 5310, those aren't applicable in a partial plan termination, and essentially the plan will kind of continue as normal. Now, the two key things here are, first, what is a significant reduction in workforce? And typically that is a 20% threshold. So if an employer lays off at least 20% of their workforce, that's going to trigger the partial plan termination. Now, that's not a black and white rule. It's a fact and circumstance test, so it could be more. It could require more than 20%. It could be less than 20%. but typically speaking, if an employer lays off 20% of their employee population, that will trigger a partial plan termination. The second key thing is who to vest. And the key phrase here is all employees who terminated in the year of partial termination. And that means even if, let's say, you lay off 20% of your workforce, but then you have another 10% of your workforce who voluntarily terminate, they retire, they get another job. All of those employees, both those that left voluntary and those who left involuntary, will need to be 100% vested as a result of the partial plan termination. So it's very important for employers to realize and take account to how many people they're laying off to make sure they don't, or if they do, trigger the partial plan termination rules, and then appropriately vest those who have terminated. The Paycheck Protection Program, it authorized up to $349 billion in forgivable loans to small businesses to pay their employees during the COVID-19 crisis. And amongst other requirements, a loan will be forgiven if the proceeds used are to cover payroll and payroll costs. And what is a payroll cost? It's typically going to be salary, wages, commissions, and tips, including employee benefits. And employee benefits will include retirement plan benefits. That will include match and non-elective or profit-sharing contributions. Now, there's a couple of things to keep in mind when determining whether your match or your non-elective contribution qualifies as a payroll cost. The first is, when is it made? And typically speaking, any match or profit sharing that's made on a per payroll basis is going to be considered a payroll cost. So any payroll that you're making during the period in which your loan covers, any match that's associated with it or profit sharing that is made with it will be covered under payroll costs. Where it gets a little bit more tricky is when you have a plan that provides for a match or non-elective contribution that's paid on an annual basis. Now, arguably, these are still going to be included because even though the match or non-elective is not paid, it's still earned during that period. And also, while the plan may specify that the match or non-elective contribution is allocated on an annual basis, there's nothing that prevents a plan sponsor from allocating that more frequently. So a plan sponsor could elect to allocate the match or non-elective contributions on a per payroll basis, thus clearly making them payroll costs. However, the second thing to keep in mind is allocation requirements. Oftentimes, employers implement allocation requirements on their match or non-elective contributions, meaning you have to have earned 1,000 hours of service, or you have to be employed on the last day of the plan year in order to earn your match or profit sharing. If those requirements, if those requirements on the match or non-elective, then arguably, especially this early in a plan year, unless you don't have a calendar year plan, you have an off calendar year plan, most likely the employees haven't earned 1,000 hours yet, or haven't been employed on the last day, thus not earning the right to the match or the right to the non-elective contribution. In those particular cases, it's questionable on whether or not that's going to be considered a payroll cost or not, because they have not earned the right to the match or the non-elective contribution. Very briefly, because I know this has been covered in our last presentation, and I'm sure plenty of other presentations that you've been a part of or literature that you've read, but the CARES Act has allowed for certain penalty-free distributions as well as some increases to loans. These are optional provisions. They're not required. And any employer that wants to allow these provisions simply needs to can allow for the provisions now in 2020 and then just need to amend the plan by 2022 in order to comply with the law. Also of note that even if your plan currently doesn't allow any sort of in-service distribution or loan provisions, the plan can be amended to specifically allow for the CARE Act. It doesn't need to allow all distributions or some distributions. It can only allow the CARE Act distribution. And then finally, crediting service. There's two types of things that employers have done to kind of help buy their time during this COVID-19 crisis. The first are layoffs, and the second are furloughs or leaves of absence. With layoff, that is considered a termination of employment. And if an employer is thinking of subsequently rehiring that individual after the COVID-19 pandemic has subsided, how do you go ahead and credit that individual service for that time off, and or what are their obligations in terms of reentering the plan? There's two ways of determining service. There's the hours of service requirement, which requires you to get a certain number of hours in order to be eligible for the plan, and elapsed time, which requires you to get a certain number of days or months. If the plan utilizes the hour of service requirement, then if you were if when you were terminated, you had already met the eligibility requirements to be eligible for the plan, upon your rehire, you will automatically enter the plan on your date of hire. If you didn't satisfy the eligibility requirements prior to your termination or your layoff, then upon your rehire, you will need to satisfy the term. So if you were hired January 1st of 2020, let go April 1st of 2020, and earned 300 hours of service, in order to be eligible in 2020, you would need to earn another 700 hours of service in order to get your 1 year of service, assuming the plan uses 1,000 hours. Elapsed time essentially works the same way. If you satisfied the eligibility requirements prior to termination, you will be automatically enrolled in the plan upon your rehire, or automatically eligible. If you didn't satisfy the terms of the plan, then you satisfy the terms of the plan before becoming eligible. The one key thing here is what's known as the service spanning rule. And the service spanning rule basically will credit all service between the date of termination and the date of rehire, provided that it does not exceed 12 months. So in the example that I just gave, where you were hired January 1st and laid off on April 1st, you would have earned 4 months of service because of your employment for January, February, March, and April. And if you were then laid off and rehired on, say, December 1st, you also would have gotten an additional 8 months of service because your termination period between April 1st and December 1st was less than 12 months. Therefore, that entire period that you were terminated counts toward your eligibility for plan purposes. So employers need to be very careful if they use the elapsed time method to make sure they're crediting their employees with the correct amount of service upon their rehire. And very briefly, the break in service rules, they're complex. They don't always come into play, but essentially, if you get less than a prescribed amount of hours, the plan upon your rehire can disregard your prior service. So if you had 15 years of service prior to being terminated, and you incur a break in service, if you incur the requisite amount of break in service, you could theoretically lose your prior 15 years you've already earned. And that kind of comes into play with the furlough and leave of absence. Typically, if you're on a paid furlough or paid leave of absence, your service is going to be counted for both eligibility, investing, and determination of the break in service rule. However, if you're on an unpaid furlough or leave of absence, you don't get credit for anything. You don't get credit for your service, towards vesting, or towards the break in service rules. However, there are 3 exceptions to that. There's maternity, paternity leave, FMLA leave, and then military leave. Maternity, paternity, and FMLA leave, you will only get credit towards satisfying the break in service rule, up to 501 hours. Those 501 hours won't be credited towards determining your eligibility for the plan or determining crediting for vesting service either. However, military, if an individual is on an unpaid military leave of absence, then they are treated as essentially having continuous employment during their military leave of absence. So it would account for both eligibility and vesting along with the break in service rules. So really what that says as far as COVID-19 is, unless someone has gone on a leave of absence that also coincides with maternity, FMLA, or military, arguably then there's no crediting of service that you would need to do for COVID-19 related leave of absences. And that is all the information that I have to present on retirement plans. And I will turn it over to Eric, who will discuss the COVID-19 and health and welfare benefit plans. Eric?
Thank you, Scott. So, I skipped a slide here. So these topics I'm going to cover are a mix of new guidance as well as just some issues we've been run into recently or we've been asked about. So the first one I wanted to discuss involves plan amendments and disclosures, and this will impact all employers because they relate to the COVID-19 testing mandates under the CARES Act and those employers who make certain optional high deductible health plan changes. The next is HIPAA security considerations for remote workers. I think these are unique challenges that you'd necessarily face in a lot of employer contexts because many times the people involving group health plan administration and what's called protected health information are working in an office. But when you're working from home, there are a lot more considerations. So next is a question I've seen come up a lot, which is not a true what we call HIPAA special enrollment event, but a question about whether an employer could choose now to let everybody who's declined coverage to now get back in the plan because they're worried about getting sick with COVID-19. Then fringe benefits, and this isn't the only, I think, COVID-19 related fringe benefit topic, but I've seen the question pop up about whether employers can pay tax-free household expenses of employees who are having to work from home due to shelter-in-place order or quarantine. Next, I'll talk about some new guidance about deadline extensions and then a few other general considerations. So regarding plan amendments, and just to recap, so the CARES Act and the legislation before it, the Families First Coronavirus Response Act, required plans to cover at no cost certain items and services related to COVID-19 testing without applying to a deductible. And it also included some optional changes for high deductible health plans that could provide certain pre-deductible coverage and not cause their participants to lose health savings account eligibility. So these types of changes, I think most plans and most employers probably won't need to adopt a formal signed amendment. Generally, or at least in a lot of cases, employers have what's called a wrap plan document, which is sort of like the bare bones structure of a plan, and then that it incorporates by reference the summary plan description and other documents which describe the actual benefits. So under that structure, and I think this is probably true with many employers, they're not going to have to scramble to sign an amendment for these changes which are already effective. That said, I have seen some plans that spell out all the specific benefits in their wrap document. If that's the case, I think technically an amendment would be required. Now, I know that's difficult because a lot of companies with everybody working remotely are not in the best position to sign a formal plan amendment, but it's something just to be aware of. From the disclosure side, ERISA requires a summary of material modifications, or what's called an SMM, for changes in plan design. Now, this is not an advance notice requirement. It's required essentially in most cases within 210 days after the end of the plan year of the change. As a best practice, I would say you generally want to provide this in advance, particularly for something like this where there's new COVID-19 testing coverage and it's really important to employees. Also, ERISA has rules about the manner in which you can provide disclosures. The safe harbor, the general rule is that you have to provide a paper copy. Now, there is a electronic safe harbor. It's pretty old, dates back to the earlier 2000s, which essentially provides that you can be deemed to satisfy the disclosure requirement electronically if you either receive the person's consent or if the person has work-related computer access as a material part of their job duties. So what that essentially means is that for a person who's a consultant, attorney, someone like that who's working on a computer, you can just provide the documents electronically. For someone who has more incidental use of a computer, say at a retail store who isn't using a computer as a part of their job but may have computer access, probably wouldn't be covered by the safe harbor. Now, just because the safe harbor doesn't apply doesn't mean these rules are violated, but then you're on sort of an actual receipt test with disclosures. So I just wanted to kind of point that out, given that a lot of people are working remotely and it's probably easiest to send ERISA disclosures electronically. The third aspect of disclosure, and this is based on some new guidance from the agencies, and that involves what's called a summary of benefits and coverage. This is a little, usually about an 8-page document that looks like a table, and it lists out the core aspects of your health plan. So with that document, if there's a change that affects the content of an SBC, actually 60 days advance notice are required. Now, with these amendments, with this legislation, which took place immediately, that's obviously not possible. So what the agencies have said is that this disclosure, again, this will be for the changes in the CARES Act, should be done as soon as reasonably practicable. So for those employers who have not provided this, it's something I think you need to get around to pretty soon. If you have a third-party administrator, they'll usually prepare this for you, so it may be worth looking to it for them. But if not, you may want to have counsel review it. Next topic is HIPAA security considerations, and I think this is an interesting topic in the COVID-19 context, with so much of the country, working under a shelter-in-place order. And where this probably comes up is where you have a self-funded group health plan. So therefore, you may have some employees that are involved in the administration of it, whether it's kind of incidentally handling claims, enrollment, etc. And I think it's important because HHS has on its enforcement website a sort of what I call a wall of shame, which is where they publish publicly their major enforcement actions for HIPAA breaches. And a lot of them involve things like stolen laptops and other devices, personal devices where PHI was not secured. So it comes up a lot. It's actually, I think, one of the more common examples of breaches. So a couple of things I think to consider with this. First is to make sure you follow your HIPAA policies and procedures just as if you were in the office. If it requires certain levels of security of data, the fact that you're working remotely, it shouldn't change that. Next is I want to give us a few examples of, I think, things to consider when you're handling PHI, or maybe even just in general when you're handling sensitive information working remotely. The first, and I think this probably goes without saying, is that you should have a private workspace. If you're working home with family members and you have a laptop out on the kitchen counter and you're looking at PHI, there's a risk of a HIPAA breach there. The next one, this is probably one of the more important one, is I think PHI should not be used on shared devices, and that includes things like printers, which can store an image of the data when you print it. So if you have a family printer and you're handling PHI, you need to be very careful about how that's being involved, whether it's you need to restrict that now to yourself or take other precautions. Another, I think, also goes somewhat without saying, but when you're working remotely, if you're printing PHI and you're handling it, if you're not in front of it at the very moment, I think you need to either shred it when you're done or store it in some sort of locked cabinet. And then lastly, this goes to some of the examples I gave about stolen devices. And it comes up a lot too now that you're maybe hauling a laptop around the place a lot. So if you have computers and devices that you're using PHI, you need to have proper security. That means not just a password, but the way in which if you're storing PHI on the computer, accessing it remotely, these are all, I think, security methods that need to be considered. For example, if you have PHI that's unsecured and you send someone an email, and I've heard of many people doing this, where you're typing in the Outlook and there's an autocomplete, and you type in one person's name and it autocompletes for someone else that you did not mean to send that document to. If you don't have proper encryption on your files and you send that, that's going to cause a breach of PHI because it's unsecured. Next topic, special enrollment. And again, I don't mean true HIPAA special enrollment here. Just for background, under HIPAA, you can have a right to enroll in a group health plan if you lose other health coverage under certain events, or in case of a newborn child. If there's a new child with birth or adoption, you can enroll that person in mid-year outside of open enrollment. So the question I've seen come up a lot is, now that this is such a serious health crisis, and any given year, the number of people just choose to decline their coverage. Maybe they don't think they need it. And now, with everything being much more serious from a health standpoint, could we have a second mid-year event where we let everyone get another chance to get into our group health plan? And as a general matter, you probably will be able to do that. If you have an insured plan, you may need the insured carrier's approval. And from what I've seen, carriers have been very open to this. Self-funded plan, if you have stop-loss insurance, similar aspect there, you may want to get stop-loss carrier approval to make sure they'll cover the excess claims. The one caveat, though, is putting aside whether you can permit this, and I think many plans will be able to allow people back in without any other special enrollment event, is that absent a permitted election change event in the cafeteria plan rules, this is things like changes in employment status that affect eligibility. A general special enrollment event like this is probably not going to be a permitted cafeteria plan election change rule. So these employees who are now let in mid-year, as just a general matter, would not be able to pay for their premiums on a pre-tax basis. They would have to use after-tax dollars. Next topic, from fringe benefits. As I mentioned earlier, I think this has been a little overlooked, and the guidance is not perfect in this context, but with everybody's expenses being what they are and the economic downturn, I think employers are looking for every cost lever to pull to save money in this kind of business climate. That includes tax savings. So with many employees having to work from home, I've seen the question pop up a lot about whether their home office expenses, such as computer, internet service, even a landline, could be paid by the employer tax-free. And when I look at the rules, I think probably, at least in many cases, this would qualify for what's considered a working condition fringe benefit, which is essentially a benefit that is tax-free if paid by the employer if the amount would have been deductible by the employee if they had paid it themselves, either as a business expense or a depreciation expense. So that's the general standard for that is what's called ordinary and necessary. And I think many home office expenses, and again, this is the facts and circumstances question, would probably meet that requirement. Just some other considerations. I hopefully will get some IRS guidance on this and maybe even for some other fringe benefit matters too. But you potentially have substantiation requirements where you have an allowance or reimbursement to make sure the expense is proper. And then I think one lack of clarity and where I'd like to see guidance is with the incidental use. So people who have home office setups or who are now setting up a home office or a temporary workspace from home are probably using that area for some personal tasks as well. And in some contexts, like with cell phone usage, there is guidance about how that can still be excludable even if there's incidental personal use. So it would be helpful to see some similar guidance in this context as well. So next, and Scott talked about some of these as well. So deadline extensions, as Scott mentioned, the IRS Notice 2020-23 extended the Form 5500 deadline for certain non-calendar year plans. IRS also issued a notice recently extending the deadline to remit HSA contributions at the end of a year. So two just kind of quick deadlines I'm going to remind. And then the third is a recent guidance that was actually issued just this week. I think is pretty interesting. So it's mostly relief for plan participants, but obviously there still is an impact on plans themselves because they have to allow this relief. So basically what the guidance provides is that plans must disregard the outbreak period, and I'll tell you what that is in a second, for determining the following deadlines or dates. So One is the HIPAA special enrollment deadline, e.g. if you have a newborn child, you can enroll them mid-year. The 60-day COBRA election period, which may be coming up now too as furloughs have been picking up. People may be starting to become eligible for COBRA. The deadline for paying COBRA premium payments, the deadline to notify a plan of a COBRA qualifying event, such as a termination of employment, the benefit claims and appeals deadlines, and then lastly, the deadline for the plan to provide a COBRA election notice. So the first 5 there are relief for participants that the plans will have to accommodate, and then the 6th is a deadline relief for the plan itself. So the outbreak period is defined as starting March 1st, 2020, until 60 days after the announced end of the national emergency. So this guidance, I think, contemplated an April 30th end of the emergency, which would mean that this relief is available through June 29th. Now, I think it's interesting about this is nobody really, I think, knows when the emergency is really going to end. And if this relief is extended into 2021, it creates some very interesting scenarios. For example, you could have somebody with HIPAA special enrollment deadline being extended that way. You could have someone who is waiting until 2021 to retroactively enroll a newborn child as of March of this year. Or you could have someone who's been on COBRA and owes March COBRA premiums of this year that doesn't have to pay them until next year. So I think those are just two interesting considerations with this. And lastly, I just want to kind of gloss over a couple other just general health and welfare considerations and things we've seen pop up. I talked about this a little bit during our last webinar, but there's a ton of interesting and I think related health and welfare rules about various leaves and furloughs, et cetera. So the first, is the continuation of health coverage requirement. Now that's something under FMLA, including the expanded FMLA under the CARES Act that has to be provided, and that includes the employer share of the premium. And in recent guidance by the DOL, they actually said for the emergency paid sick leave, which is not FMLA, a plan could not terminate coverage during that period based on HIPAA and ACA non-discrimination concerns. Next is the payment of premiums for the furlough or leave. Now for FMLA, there are certain methods that can be used and certain that cannot. There's a prepayment method, a pay-as-you-go method, and a catch-up method. Under FMLA, the prepayment method can't be the only option offered. And I've seen a lot of employers that are choosing this sort of catch-up method, which essentially takes out the prior month's premiums out of the employee's paycheck when they return from the leave. I think that's been a little more popular because of everybody's financial strain. And lastly, ACA employer mandate considerations under furloughs and leaves. So when someone is put on a leave or is on a furlough, and you're not required to continue coverage, such as an unprotected leave, you still may have some ACA exposure if the person's considered a full-time employee. For example, they're in what's called a stability period, and if they're placed on a furlough, they're still a common law employee, so there can still potentially be ACA exposure. Next is there was some tri-agency guidance regarding these COVID-19 testing mandates. Just to give a few highlights from that. So the applicable period, it starts March 18th, that was when these requirements took place, and it runs through the end of the public emergency. So that reflects, at least generally for now under this guidance, how long this special COVID-19 testing coverage has to be provided. One other important, I think, clarification was that the guidance stated that antibody tests were also covered by this mandate, and whether plans were going to choose to cover those anyways, I don't know, but I think it's an important thing to be aware of. And in terms of an economic impact, I've read a lot of people say that the antibody tests are in many ways as important as the regular COVID-19 tests for purposes of figuring out who may be immune now and in terms of being able to open up the economy. And then another just quick point about this, and this I think was cleared in the legislation as well, but this coverage mandate is for both network and non-network benefits. So if you have a non-network benefit, the rule is that you have to pay the publicized cash price on the provider's website, and providers are required to post that information. Another provision, this is in the CARES Act, and I felt like this one was overlooked a little bit more, maybe because it's more incidentally related to benefits, but there's a permitted deferral of FICA Social Security tax payments for employers. Now, it doesn't cover the Medicare portion, But essentially, it provides a two-part deferral. 50% of these Social Security taxes can be deferred up until December 31st of this year, of next year, and then another 50% the year after that. Then lastly, just a quick reminder, I think this is actually one of the more neat provisions in the CARES Act, is that it provided that employers could pay tax-free certain amounts of student loans of their employees. The cap on that is they can pay up to $5,250 of eligible student loans. And then there are also a few other requirements that have to be met, but as a general matter, I think this is a pretty widely available provision and, again, potentially a good tax lever for employers. So on that note, I'll turn it over to Ann Tyler, and she'll cover the executive compensation aspects.
Great. Thank you, Eric. So today we're going to be talking about Code Section 409A and permissible distribution events for non-qualified plans. We're also going to be talking about whether mid-year deferral election changes are actually permitted under 409A. Then we're going to talk about the CARES Act and executive compensation limits that apply to employers that receive certain loans and loan guarantees under the CARES Act. And then what types of pay are included in this compensation restriction calculation. And then finally, we're going to talk about ESOPs and the impact of COVID-19 on ESOPs and interim valuation considerations and whether ESOP-owned companies are actually eligible for the Paycheck Protection Program and economic injury disaster loans. So diving right in, separation from service, distributions generally in the context of unpaid furloughs or leaves of absence raise questions about whether there's actually been a separation from service. And we touched on this in the last webinar, but I wanted to emphasize that a separation from service is presumed when the level of services by the employee is reduced to no more than 20% of average services provided by that employee in the preceding 36-month period. But again, the idea here is that it is a permanent separation from employment, that there's no contemplation that this individual would return as an independent consultant. This is not a furlough. A true separation from service is that this individual's services are reduced to no more than 20% of the average services provided by that employee in the preceding 36-month period. And this is important because under Code Section 409A, which governs non-qualified plans, if there's a violation and a distribution when a separation from service has not actually occurred, that there's an additional excise tax equal to 20% plus interest on top of the ordinary income tax that would be owed on the amounts that pay out from the non-qualified plan. So very important to comport the operation and the plan document with the Code Section 409A rules around separation from service. And to be clear, a separation from service has not occurred. Again, if there's a reasonable expectation that the employee will return to employment, and then the regs, the 409A regs, contemplate that if an executive's average services still amount to 50% or more of the average services provided by that executive in the preceding 36-month period, then that executive is presumed to have not separated from service. So if you have an individual who typically works 40 hours a week and his or her hours are reduced to 20 hours per week, then under this definition, there's a presumption that that executive or that individual has not, in fact, separated from service due to that reduction in hours. If the reduction amounts to average services totaling 20 to 50% of the average services provided by that executive in the preceding 36-month period, then there's a rebuttable presumption, and it would be a facts and circumstances analysis. But the point should be made that non-qualified plans, deferred compensation programs, aren't really aimed at addressing short-term cash crunches, and the ability to access funds by participants is limited. So participants may want to consider other options for accessing funds. Another issue that's come up is reductions in pay, and whether individuals who've experienced a reduction in pay and have maybe fallen out of the plan's eligibility provisions. Code Section 409A does not permit suspension due to the loss of eligibility mid-year. So deferrals in a non-qualified plan must continue for the remainder of 2020. Additionally, if there have been mid-year bonus adjustments, this reduction in bonus amount would not affect an otherwise valid deferral election, and the employer should just accommodate that adjustment by taking a percentage deferral of the lower bonus amount. Okay, now we're going to turn and look at executive compensation limits related to certain loans provided for under the CARES Act. So loan guarantees and investments provided for under the United States Treasury's Exchange Stabilization Fund, specifically under Title IV of the CARES Act, provides for executive compensation limits to be eligible for these loans and loan guarantees. And these executive compensation limits apply for the limitation period, which is defined as the date that the loan agreement is signed or executed and ending 1 year after the loan is repaid or is no longer outstanding. So what are those limits? The first limit is that no officer or employee whose total compensation exceeded $425,000 in calendar year 2019 may receive during any consecutive 12-month period, including the limitation period, total compensation more than the total compensation the officer or employee received during the calendar year 2019. So for the limitation period, this individual, this executive cannot receive, for example, more than $425,000 in compensation. In addition, severance pay or other benefits on employment termination that exceed twice the maximum compensation the officer or employee received during calendar year 2019 is not allowed. So, for instance, an executive with 2019 total pay of $800,000 could not be paid more than $1.6 million as severance pay or other benefits. Now, this other benefits is not defined. We presume that it would include health coverage, pro rata bonuses, other items of remuneration triggered by an involuntary termination of employment. We'd also presume, although it's not clear, that benefits not accrued or that are not payable upon a voluntary resignation, such as benefits under a non-qualified deferred compensation plan or a tax-qualified retirement plan, that those amounts would not be included in this other benefits definition. But it's unclear, and we'll await further guidance on what that explicitly means, other benefits. Additionally, these executive pay limits for certain loans under the CARES Act preclude officers or employees whose total compensation exceeded $3 million in calendar year 2019. It precludes that during any consecutive 12-month period within the limitation period, total compensation in excess of $3 million and then 50% of the excess of the $3 million of the total compensation the officer or employee received during calendar year 2019. So an example is if Executive A made $4 million in 2019, his or her compensation for 2020 is limited to $3.5 million. So $3 million plus half, 50% of the excess over $3 million. So total compensation for purposes of this limit includes salary, bonuses, stock awards, and other financial benefits. Another term that is not explicitly defined, but we presume that that means non-tax, any type of salary, bonuses, stock awards, pro rata bonuses, any other items of typical wage and what would be considered typical remuneration. But it's not completely clear. We'll await further guidance on that. It's also unclear to us what would happen if this compensation limit is exceeded, how this is accommodated. So is the compensation to be reduced to comply with the restrictions? And if so, what compensation, what aspects of the compensation is reduced first? Whether a covered employee has any choice in this reduction, how such compensation items are to be valued for this purpose. So a lot of unanswered questions, but we have some general guidance around these limits. And so if you are an employer or you work with employers who have obtained loans under Title IV of the CARES Act, important to be aware of these executive compensation limits. And then specifically what happens to total compensation to which a covered employee has a contractual right that cannot be paid currently due to exceeding the applicable compensation limit. And is this something that would be deferred? How would this be accommodated? If it's something that can be deferred, then obviously that implicates 409A considerations. And we strongly recommend that counsel be consulted as to how to arrange this deferral. Finally, we're going to talk about ESOPs in the context of COVID-19. Employee stock ownership plans. This is a program where employees own stock in the company, essentially own the company. And pursuant to the ESOP rules, company stock must be valued at least annually, and that's typically done on the last day of the year. And this is important. Annual stock valuations are important because it's used for participant distributions and diversifications until the next annual valuation. So the issue here is that many 2019 ESOP valuations are in process, but cannot account for this current economic downturn because it was not foreseeable as of the end of 2019. Now, many of the ESOPs that we work with have the ability to set an interim valuation date for special situations. And if not, then the ESOP can be amended to provide for an interim valuation date, but this amendment must be made on a prospective basis only. And it's important to note that if you are an ESOP or you work with employers, companies that are ESOP owned, then it's important that if you're considering adding an interim valuation date, that is a fiduciary decision. It must be made in the best interest of plan participants and beneficiaries. And with that in mind, electing an interim valuation date comes with additional costs, including the ESOP trustees' independent appraiser costs, and all facts and circumstances should be weighed by ESOP fiduciaries before deciding upon whether to elect or add an interim valuation date. But this is important and relates to specific considerations for ESOPs because employees have the right to force employers in the ESOP context to repurchase shares at the current value. And so this put right implicates cash flow requirements. And this repurchase liability may implicate the company's survival or insolvency during this economic crisis. And so terminated employees receiving a distribution of shares from the ESOP and the simultaneous cash out request by a number of employees could result in a significant financial strain upon the ESOP sponsor. And if these cash outs, again, this is why the interim valuation is so important, if these cash outs are done at an inflated share value, it arguably disadvantages the remaining ESOP participants. There's some special and explicit considerations in the ESOP context and the need for consideration around an interim valuation for the ESOP. Finally, just did want to note that ESOP-owned companies do in fact qualify for the Paycheck Protection Loan Program under the CARES Act. And ESOPs are permitted to use the proceeds from the PPP to cover ESOP contributions, ESOP distributions, diversifications, and exempt loan repayments. Note that the PPP loan application should be signed and certified on behalf of the Employee Stock Ownership Trust, the ESOT, and by an authorized signatory. And in calculating the PPP loan ceiling amount, companies that have paid cash contributions to their ESOPs during the measurement period should in fact include those ESOP contributions in the calculation of the payroll costs in their loan applications. So it's a welcome relief for ESOP companies as well under the PPP provided for in the CARES Act. That concludes our presentation. Please email us any questions at admin@hallbenefitslaw.com. We also hope that you'll sign up for our newsletter. We're releasing weekly guidance and the myriad of changes that are coming about as a result of the coronavirus pandemic and the impact on benefits. So please do email us any questions from this webinar or any other benefits-related questions. We welcome the opportunity to speak with you about that.